Hello, everyone. Thank you for joining us today. By way of introduction, I'm Adrian Ang, and I'm a executive committee member of the Singapore FinTech Association. I'm also a partner at Allen and Gladhill, where I take care of its FinTech business as well as its ESG business. And my area of practice also includes financial regulatory work. Thank you so much for taking the time to join us today. This is actually the third installment of a series of 3 seminars. If you were able to join us for the previous 2 seminars, you will know that basically it covered employment law as well as insolvency law. This current seminar will cover mediation as a form of dispute resolution. Now, how did we arrive with this set of 3 seminars? Basically, you would see in the newspaper headlines multitude of unfortunately bad news. Basically, you would have seen headlines like Shopee retrenching its employees, Coinbase freezing its employment contracts. You would also have read about Three Arrows. In fact, it's in the Straits Times today, being investigated by the US regulators and facing insolvency. Home Not, a Singapore fintech company that received its in-principle approval only to have it withdrawn subsequently. And of course, Terra USD Luna, where the stable coin was purported to have some amount of value or some value, and now it's almost zero. With the founder basically being investigated by the Korean authorities. So in light of all of this, we thought it would be quite topical to bring you a series of seminars where we talk about employment law, retrenchment, and what employees and employers can expect. We also talked in the second session, we also talked about insolvency, both from the perspective of the insolvent company or the company that's going into insolvency, as well as people who face counterparties that might become insolvent. Finally, I think the reason for this third installment is, well, the SIMC, the Singapore International Mediation Center, is fairly new, and we wanted to introduce or provide further information about the SIMC to our members. In addition, we also wanted to highlight this idea of a separate kind of dispute resolution. You don't necessarily have to go to court. You don't necessarily have to go to adjudication. Mediation is there as a separate way of dispute resolution, and the SIMC is a great place for doing that. Now, we're very, very pleased to have with us today Bennett Lee to take us through the SIMC information. Bennett is actually the registrar of the SIMC, and he's had a really storied career in law. He's an alumni of A&G, being a partner here a couple of years ago. So besides being in private practice, he was also as in-house counsel in again very reputable firms such as Lion Global. So he's seen it both ways, from the in-house counsel perspective as well as the private practice perspective. And in addition to that, he's also taught at the university, NUS, where he continues to be an adjunct professor. So we're very, very fortunate to have him here with us today to speak to us about the SIMC. So, and if you have any questions in relation to the topic that's being discussed, please put your questions in the Q&A portion. We will take it up at the end of this seminar. And of course, if you want to raise it verbally, please feel free to do so at the end of the seminar as well. Okay, without further ado, Bennett, please, over to you.
Okay, thank you, Adrian, for the introduction. Let me share my screen. Okay, let me start by showing you this picture of a statue that is along the Singapore River, just outside Fullerton Hotel. I think many of you would have passed this statute, but I think most of us, like myself included, used to walk by without actually knowing what it was all about. And there's actually a plaque next to the statue. And I want to show you what the plaque actually says. Okay. Now, this is what the plaque actually says. You will find that actually this statue is a scene from a mediation that occurred during the time, which would be around the year of 1820. So just about a year after Singapore was founded. And you see this guy called Alexander Laurie, who is actually mediating between a Malay and a Chinese man. And we presume it's over the goods that are being, over a dispute relating to the goods being unloaded on the side. But so next time when you go by the Singapore River and you see this statue, do spend some time to read the plaque. So as you can see, mediation is not new. It's something that's been around for a very long time, except that over the years, I think people have resorted more to the courts to resolve their disputes than through mediation. So this is just an introduction, some trivia for you. Okay, so let me start by talking about what mediation is, because all of you know what litigation is about. Going to court, adversarial, both parties present their cases and the judge rules at the end of the day, right? Arbitration is more or less similar, except that it's confidential. The process is kind of, you can choose your process because there are different rules to arbitration. But again, it is adversarial. And at the end of the day, an arbitrator decides on who should get the award, okay? Make the award in favor of one party or the other. Mediation, on the other hand, is actually very similar to negotiations between two parties, except that there's a neutral third party involved, which tries to facilitate the process, okay? So this is what mediation is about. And unfortunately, mediation is not, the term mediation can take on different forms in different countries. And sometimes it gets a very bad reputation because it is conducted in not the style that we know mediation to be in Singapore. And I'll explain why later, okay? So this is what mediation is all about. But really, I want what the whole idea, the whole gist of today's talk is really to introduce you to not just mediation, but the benefits of mediation, okay? And as Adrian said, I'm very fortunate that I was trained by the several icons of Ellen and Gladhill in the past, people like Michael Huang, Penny Goh, Femala Rajamanikam, and they really showed me the ropes in Ellen Gladhill. And I'm very happy to do this talk because of my association with Ellen Gladhill. But through that process of learning and also in practice, and also in my own private practice, I learned that there are quite a lot of limitations to litigation. There are certain things that you can achieve through litigation and some things which you can't. And some of the difficulties and obstacles to mediation, which we'll come to deal with in a short while. Okay, so I've been both on the side of the parties representing them, as well as being a client when I was an in-house in some companies that I worked for. So I have been both on the side of an advocate as well as on the side of the client. So what you see here from the benefits of mediation is not something I took out from a textbook, but really is culled through my experience of the legal process of dispute resolution. So there are actually four main benefits of mediation. One is that it preserves neutrality and confidentiality. The second is that parties have full control over the outcome of the dispute. Okay. The third benefit is it is non-adversarial and flexible, and its flexible nature preserves the relationship between the parties. And finally, there are time and cost savings. I'll deal with each one of these in greater detail following this. Okay. Okay, let's deal with the first one, benefits of mediation. Preserving neutrality and confidentiality. Okay, I think this is quite similar to arbitration because arbitration is also held privately as like mediation, but so it is good for certain kinds of cases and disputes. In particular, since you were talking about employment, employment is a very good good kind of dispute for mediation. And you find that a lot of the very big companies, global companies, would rather mediate their disputes with their employees more for reputational reasons than anything else. And even the employees also sometimes do not want their confidential information relating to their employment to go public. So mediation, of course, arbitration is also confidential, but mediation is a means for employment disputes to be settled privately. The other kind of disputes that is very suitable for mediation relates to family disputes. Again, there's a lot of private matters in family disputes, and SMC has mediated a lot of family disputes where the parties just cannot see eye to eye on how the estate should be divided, or or how certain family companies should be run after the matriarch or the founder has passed on. So these are issues, again, highly confidential. Mediation is a good way to settle the dispute. So cases which have reputational implications tend to be very suitable for mediation. The other advantage of mediation is it can be held anywhere the parties agree on. It doesn't even have to be in the court's room. It doesn't have to be in the annex to the courtroom. You can hold it in a hotel, you can hold it in a dedicated mediation facility, such as Maxwell Chambers, or you can hold it in any conference room, so long as you have the facilities to hold the mediation, okay? So some people just want to hold mediations far away from the law courts to avoid the glare of the public. In case they meet people they don't want to meet in the courtroom setting. Okay. Where parties are from different countries, they can choose to mediate in a neutral venue. So Singapore is is seen as a neutral venue to many people because it kind of where East meets West, and sometimes one party from the US or Europe may say they want to hold it in Europe. Another party from Asia says they want to hold it in, say, maybe Hong Kong or whatever. And then they kind of default. They say, why don't we hold it in Singapore? Because that sounds very neutral to both of them. So we do get a lot of queries like this where the mediation relates to disputes that have nothing to do with Singapore. The parties are not from Singapore. The dispute relates to subject matter not even related to Singapore. So this is another advantage. Mediation can be a viable alternative where the dispute arises in a jurisdiction where the legal system is not so well developed. Okay, in some countries, you may not understand the legal system, or you may have some reservations about the legal system. Mediation takes that completely out of the equation because you don't have to rely on the courts there. You don't have to rely on the legal system or the law there because you're not familiar with the system or how it works. Mediation, as you can see, is really under control of the hands of the parties. So the second benefit, like I said, just alluded to, is that parties have full control over the outcome of the dispute, okay? The parties can choose their own mediator or even mediators. You can have more than one mediator, and contrast that to litigation where you cannot appoint a judge, or if you want two judges, you cannot say, I prefer to have two judges instead of one, okay? Parties can also choose a mediator with specialist knowledge in the area of the dispute. Parties choose their own rules of mediation. Parties can still remain represented and advised by their legal counsels throughout the mediation, so they do not feel they are left alone. They might be taken advantage of because they have legal counsel at their side all throughout the mediation, okay? And most importantly of all, the parties decide the outcome of the mediation. There's no ruling that is enforced on either of them, unlike a court judgment or arbitral award. So underlying mediation is the fact that it is voluntary. Both parties must agree to come to mediation. You cannot serve a writ or summons on the other party and force the other party to come to mediation, as you can say in a court where you can just summon the person to court. You can't. In mediation, both parties must agree to come to mediation, and the decision is actually crafted by both parties with their full consensual agreement, okay? So there's no ruling imposed on one party or the other. The next benefit is that it's non-adversarial and its flexible nature preserves the relationship between parties. This is a very important benefit of mediation, which you will see later as we go along. First of all, benefit the parties start on the right footing because both parties agree to mediate. As I said, it's voluntary. Okay. By contrast, litigation is started by one party and not by the choice of the other party. Okay. So both come together and say, we want to settle this if the conditions are right. Okay. And what makes mediation different is that it is non-confrontational. So the parties get to interact in a less highly charged setting rather than through lawyers' correspondence, which tend to be acrimonious and only stress the strength of their own side's legal case. So in this kind of setting, people can discuss in a less heated fashion and try to understand where the other side is coming from. And indirect benefit of mediation is that there is no authoritative figure presiding over the proceedings. An arbitrator has the power to impose an award against one party. A judge, similarly, can rule against one party. The mediator, on the other hand, has no such power. And because he has no power indeed to decide how the mediation ends, the parties don't feel that any pressure to settle. Okay. Now, in some jurisdictions, for instance, in China, unfortunately, they practice a different form of mediation than in Singapore. In the court structure, they may force the parties to go for mediation first, but the mediator is the same judge. And so if the mediation fails, it goes back to the judge for the trial. It's the same judge, and you can imagine that if that mediation, he already has a view towards a certain party, it's not going to help you very much if you go to litigation. So you might be forced to settle before it goes to litigation. So unfortunately, that's not how we practice mediation here, but that's what's happening in China. So mediation adds a human face to the dispute before the full-blown litigation or arbitration. Okay. I have experienced this firsthand. I mean, very often you don't see the other side's client until the day of the trial, or there is some hearing before the court, and you do not see who is behind the opposing side's lawyer, who is the person giving the instructions. Actually, the person might actually be a very reasonable and friendly-looking person, but you assume the worst because you have never seen the person on the other side. And so I think the putting a human face to the dispute actually helps in the mediation process. Another advantage of mediation is that in litigation, you do not see judges speaking to the litigants privately. By contrast, mediators speak to the disputing parties as a matter of course to get a better understanding of what their underlying interests are and to seek a common ground between the parties. Okay, when we say underlying interests, you'll find that here we're not talking about legal rights. It goes beyond legal rights. So sometimes the dispute is not because of legal rights, but it's because one party is hurt by the other party's actions, and there can be a lot of emotions involved. Some people just want to litigate on the basis of principle because they feel they've been misled, they feel they've been let down, and they're very disappointed with the other party. It's through mediation that we can resolve all these underlying hurts and interests and really get to the bottom of what is stalling them from coming to a common agreement. So even in cases where one party has stronger legal rights, many of them realize that it's really not in their interest to go to a full-blown litigation because the time involved, the cost involved, the reputational risk involved, and sometimes it is because there are ongoing projects, like for instance, infrastructure projects. We've seen cases where the parties are in dispute, but they realize that the infrastructure project still needs to go on. And sometimes they even have other projects that are not in dispute. And so the relationship between the parties needs to go on, and they find a way to settle the dispute through mediation. Mediation is conducted on a without prejudice basis. And for those who are lawyers, you know what this means. So that nothing that is disclosed in the mediation proceedings can be used in subsequent arbitration or litigation against the other party. So for instance, if a party has made an offer to settle on certain terms, those terms and offers cannot be brought up in the subsequent arbitration or litigation should the mediation not result in a settlement. Now, very important is that unlike arbitration or litigation, in a successful mediation, one that I would say that ends in a settlement agreement, no party feels like a loser, and each party feels that they have gained something. The settlement agreement is by mutual agreement, and the cost of the mediation is usually shared equally. There's no an award of cost against one party. Okay, so the settlement agreement, the terms, how it's going to be settled, is really by the agreement of both parties. The mediator has no say in imposing any terms on the parties. So, like I said, the key benefit of mediation is it preserves the relationship and even repairs the relationship of the parties for future mutually beneficial dealings. I have seen mediations where the parties end up settling and then going out together for drinks with smiles all over their faces. You know, we have a photo of these kind of events, but we can't show it because of the confidentiality of the proceedings. But you'll never see a scene like this after a litigation or arbitration because somebody inadvertently feels like they have lost and the other party may be celebrating, but they'll be celebrating alone. Okay. Now, if mediation is successful, it can, in some instances, even expand the pie available for distribution between the parties, resulting in a win-win situation for both parties. This may not necessarily happen all the time, but there are instances where this can happen. And it's because mediation allows people to think out of the box. It's not just about legal rights and legal provisions, contractual provisions. Sometimes you can just add in different things, give and take, and they trade new things, right? So I'll give an example later when we close of this. Finally, the last benefit of mediation is time and cost savings. In some countries, I won't name which ones, I think you know, a court case can take years to come before a judge due to a backlog of cases, and the witnesses may have retired, passed away, or, you know, and you have a problem even getting to the first trial, let alone the appeal. By contrast, time to mediation is quick, usually about a month, and it can even be a week if both parties cooperate. We've arranged mediations within a week if both parties are prepared to work at it and cooperate and do all the necessary. So mediation can result in substantial savings in both time and money compared to arbitration litigation because most mediations take only 1 day. The longer mediations take 3 to 4 days, 5 days at max, but usually I would say about 90% of the cases are settled, are allocated 1 day for mediation. So you don't spend a lot of money on mediation. In mediation, there are limited documents to file, and there are no ancillary applications to stall the proceedings. I think those in litigation will know that you can take a long time to get to trial because there's so many ancillary applications, interlocutory applications that bog down the whole process. Cases can drag on for years. Okay, I'll just give an example. The Madoff fallout that occurred like 20 years ago, 20, 25 years ago. The cases are still going through the courts in the US. And they have not even gone to trial. They're still stuck with ancillary applications. Okay, so this is something that mediation doesn't put you through. Finally, parties do not suffer from a war of attrition, from rising legal costs with no end in sight to the litigation or arbitration. This levels the playing field for parties who do not have deep pockets. So you can imagine a man in the street fighting against, say, a multinational. Sooner or later, the man in the street, unless he's pretty rich, is going to run out of money. And the institution can just hang on and wage a war of attrition. So mediation only costs marginally more to the parties, even if it does not result in a settlement agreement. Like I said, it usually lasts only a day. If it settles, it settles. It doesn't settle, we proceed on to arbitration or litigation as the case may be. Now, even if mediation does not result in a settlement, it helps to crystallize the issues. including non-legal issues that are most critical from each party's perspective before it goes to arbitration or litigation. You get to understand why the other person is being so difficult. Sometimes it's because of non-legal issues, it's emotional issues. It could be cultural issues, it could be some misunderstanding, but it does help you to crystallize the issues when you go to court or arbitration. Finally, any settlement offers made in the course of mediation can be the fallback position if litigation or arbitration drags on with no end in sight. The parties can actually approach each other again and say, look, we had this fallback position during mediation. Would you like to go back to it and let's try to figure out something that works for everyone? So some parties do come back for follow-up mediation. Okay, just to summarize the difference between these. Okay, let me go back over one slide. Okay, I want to stress that there is no, although we always talk about successful mediation being something that ends in a settlement, conceptually, I believe that there is no such thing as a failed mediation, because even if there's no settlement agreement, there are benefits from the mediation. And I'll just give you an example. We had a mediation for a medical negligence case where unfortunately the patient died and the family is suing the hospital. Okay. The doctors came for mediation, the aggrieved family members came for mediation. And in the course of the mediation, the doctors shared their side of the story, and there was no settlement, okay? But when the parties were leaving the room, the doctors came up to us and said, we're very happy that this mediation took place because it gave us a chance to express our feelings and our condolences and what we tried to do to save the patient, all that we tried, okay? It gave us a chance to see the aggrieved family face to face. And some of the doctors throughout the proceedings were even in tears. Yeah, so the family members could see that, you know, it affected them very badly as well. It's not just the aggrieved family. So in this kind of situation, I think that there are benefits to mediation because the aggrieved party didn't see the hospital as just a cold institution. There were people behind it, and they could see firsthand the efforts that the doctors put in to try and save the patient. So, like I said, there should not be a mediations that do not end in a settlement agreement should not be considered failed mediations, even though statistically we do tend to equate success with settlement. So just to summarize the differences between litigation and mediation, the level of formality, okay? Arbitration and litigation tends to be formal, mediation is very informal, okay? The decision maker is the judge or the arbitrator, but in the mediation, the decision maker are the parties themselves, okay? The third difference is the basis of resolution, okay? Arbitration and litigation looks at legal rights, what is contractually provided for, what the law provides for. In mediation, we look at those, but we also look at the interests of the parties. What is their underlying interests? What matters most to them, aside from the legal rights and legal clauses, right? Then the basis of interaction is also different. Adversarial in litigation and arbitration, whereas it's collaborative in mediation. And finally, the difference is litigation arbitration tends to look at what happened, looking back at the past, whereas mediation tends to focus on the future. How can we move forward, considering that what has already happened? Okay, so it's quite different. Okay, now the growing adoption of mediation in dispute resolution internationally. Let me share with you some statistics. You'll find that this is a hybrid ADR, meaning hybrid between arbitration and other forms of dispute resolution methods. This is a survey done by Queen Mary, University of London, and White and Case in 2021. And you find that in the international arbitration, more and more people are using not just arbitration, but also alternative dispute resolution, including mediations. So you see the trend on the right-hand side where arbitration plus something else is being added, okay? Now, this is a very recent report by CIDRA. And CIDRA, for those who are not aware, stands for the Singapore International Dispute Resolution Academy, which is a research center at the Singapore Management University School of Law. Okay, so they conducted this survey to understand user experience and satisfaction with international dispute resolution mechanisms. And they looked at litigation, arbitration, as well as mediation. And let me share with you some of the findings. Well, the respondents were basically client users and also external counsels, people like counsels from Allen and Gladhill. So you find external counsels make up about 78% of the respondents. Okay. There were 139 respondents from 25 countries, and you'll find it's both a mix of civil law and common law countries. But having said that, majority of the respondents from Asia are from Singapore. So why did people choose mediation? Okay, so the five most important reasons they chose mediation were preservation of business relationship. As I indicated to you previously, litigation and arbitration tends to ruin the relationship after it is over. Mediation gives you a chance to preserve the relationship. Okay, confidentiality, which is fine, is also a high requirement, but it's also satisfied by arbitration. Indirect cost to client business. Now, this again is another feature of mediation because it takes so little time to complete a mediation. It does not take up a lot of management time. It does not take up a lot of other resources. Okay, and finally, speed and cost are the other five major factors. Why they chose mediation. Now, in terms of actual experience, what did they get? Key satisfaction from mediation. Preservation of business relationship ranked very high at 78%. Indirect cost to client business again ranks very high because, like I said, it's done very quickly. You get it over and done with quickly. If it's settled, it's settled. If it's not settled, it does not put a drag on management time or operational efficiency. Finally, confidentiality, like I say, is common to arbitration as well. Cost and speed. Okay? So these are some of the reasons or the benefits they saw in mediation out of real life experience. Then the next question is, why did people come to mediation? Okay. Of course, now you know that the rules of court have changed, and mediation is probably going to get more popular because of the duty of counsel to actually consider amicable forms of settlement before litigation. But apart from that, the contractual obligation was the biggest reason why people came to mediation because it's provided for in their contract. And that's why we have an SIMC model clause, which I will not go into detail, but basically it's just a clause that parties would consider going to mediation. And question then is, why have a mediation clause? Because it is voluntary, right? And it's true, you can come for mediation even if there's no pre-agreement in the contract. Parties can still refer to a dispute to mediation at any time, even after court or arbitration proceedings have commenced. If both parties agree to go for mediation, they can go for mediation. You don't need a clause. But the clause is only helpful because it brings parties to the table to mediate by default. And even if one party is not inclined to mediate, it might change its stance once it is at the mediation and has had a chance to hear out the other party with the mediator's facilitation. So a mediation clause is helpful, although not a prerequisite to mediation. Obstacles to mediation. Okay, misconceptions about mediation. One, low likelihood of success. This is a myth because globally and as well as in SIMC, the settlement rate is between 70 to 80%. Okay, so it's a very high rate of success if you consider settlement as success. Unenforceable outcome, a waste of time. Again, this is not true, as I will try to go through quickly later. Costly, again, like I say, it's not costly because 90% of the cases, mediations take only 1 day. Wrong mindset, okay? Entrenched position, matter of principle, okay? These kind of situations, if they cannot get beyond this matter of principle issue, it can be an obstacle to mediation. Unrealistic expectations, okay? Counsels reverting to litigation mode. Unfortunately for legal counsels, we are not trained in mediation. Well, it's getting more popular now. There's finally, I mean, in the last 15 years or 20 years, I think there's a mediation course, optional course in NUS Law School. So it's getting better, but in the past, mediation was never taught in schools. And the legal training is always about litigation, adversarial, and lawyers are trained to be bloodhounds. Okay, so some lawyers feel that they have to put up a fight in front of their clients to justify their fees, and they can revert to litigation mode, addressing the other parties in a hostile manner. But I think things are getting better. So lawyers actually need to be trained to facilitate mediation. Misalignment of interest. Okay, of course, issues of legal costs, whether dragging out would bring more legal costs to the lawyers. Conditional fee arrangements may incentivize lawyers not to settle. Okay, so these are things which are slowly changing. I think people realize that the long-term preservation of relationship with a client is more important than just dragging out a case. Okay, sometimes it's because the party has a need to report to a higher authority and cannot be seen to be weak settling, and so they'll try to push for a very unreasonable reasonable terms to satisfy their higher ups. Then there are cases where they just want to go to court to set a precedent, to deter as a deterrent, say IP cases. Okay. Now, enforcement of settlement agreements. Let me try to run this quickly. Of course, as a contract, you can always enforce it as a contract. The other way to do it is to settle through getting it recorded either as an order of court or as an arbitral award. Okay, so we have tie-ups with these various courts and arbitration centers where a mediation, once settled, can go back and be recorded as a consent arbitral award, which is then enforceable over 170 countries under the New York Convention. Local legislation may also allow for settlement agreement from mediation to be registered as an order of court and enforced in the same manner as a judgment. And finally, the Singapore Convention on Mediation helps. Okay, so this is one, what do you call the SIMC up protocol. Like I say, if you start arbitration in SIAC, you can request to go under this protocol, and it then goes straight to mediation as SIMC, where if the mediation is not settled within 8 weeks, it goes back to SIAC. But if the 8 weeks needs to be extended, the parties can request for an extension. And if there's a settlement, it goes back to SIAC and is recorded if the parties agree as a consent arbitral award, and that is enforceable globally under the New York Convention. Okay. Now we have a new protocol with China's Shenzhen Court of International Arbitration, where mediations mediated by us can then be recorded as an arbitral award through the SCIA, and then it enables enforcement of SIMC mediated agreements in China. So the Singapore mediation legislation are the two main ones are the Mediation Act. And basically, the Mediation Act allows any party to a mediated settlement with the consent of the parties to the agreement to apply to court to have the agreement recorded as an order of court. But there are some provisos, conditions to be fulfilled. And the first one I want to highlight is the mediation was administered by a designated mediation service provider, or if the mediation was conducted by a certified mediator. Now, a certified mediator is defined as someone accredited under the Singapore International Mediation Institute, CMI. Okay. So if you don't have a mediation by a certified mediator, you can still go under the Singapore Mediation Act if it is administered through a designated mediation service provider such as SIMC. Okay, such agreement, once recorded as an order of court, may be enforced in the same manner as a judgment given or an order of court, order made by the court. So you can choose any mediator. It doesn't even have to be on our panel. As long as they go to SIMC, the Singapore Mediation Act will apply, provided it falls within the ambit of the Act. Okay. Now, the Singapore Convention hopes to do what the New York Convention did for arbitration, okay, by making mediation agreements enforceable through all its signatory countries. Okay, these are the primary aims of Singapore Convention. I will not go through it, but main thing is that it came to force on 12th of September, and all the states can still accede to it, even though it's came to force on the 12th of September. So the effect of the convention is basically allows parties to enforce settlement agreements in accordance with the rules and procedures of the state that signed the convention. Okay, and it also can be used as a defense where a matter is raised again in another country. The other party can raise the settlement agreement and say that the matter has already been resolved by mediation, and so that litigation cannot proceed. as of today, 55 countries have signed the convention and 10 countries have approved and ratified. Okay. I wouldn't go too much into this, but I just because there's some lawyers here, I thought it'd be helpful. The Singapore Convention applies to settlement agreements resulting from mediation. It must be in writing and it must relate to a commercial dispute and it must be international in nature. Okay. Now, what is meant by international basically is looking at whether the parties are from different places of business, different places of business are in different states, or if they are from the same state, then where is the subject matter of the agreement or the dispute? Then it does not cover things like personal injury, family or household purposes, family inheritance or employment law. And it doesn't cover cases where you can enforce it as a judgment or as an arbitral award, because it's not what it's meant to be. It's meant to cover a loophole where you cannot get a judgment or you cannot have an arbitral award. Yeah. There are various ways to set where the state can decide not to enforce a settlement agreement. I will not go through this. You can look it up in the Singapore Convention on Mediation. But importantly, there's a reservation. In other words, the member state can say, I will sign the agreement and I'll ratify it, but it will not apply to the state or any of its governmental agencies. Or it can say the convention will only apply to the extent the parties to the settlement agreement have agreed to apply the convention. So there is a reservation clause. Okay. Now, my final word on enforcement of settlement agreements, because unlike arbitral awards and judgments, the settlement agreement was arrived at through the mutual agreement of both parties. So in most cases, you don't need to enforce it. So this is a potentially additional benefit of mediation. You don't have to enforce a settlement agreement in most cases because the parties agreed to the terms themselves. Now, as I see, I just give a short introduction because it's not for profit. So we try not to turn people away from mediation on account of costs. We try to cut the cloth according to the size of the cloth. Parties want to mediate and they cannot afford Maxwell chambers, we can find cheaper premises. Okay, so these are all ways that we try to facilitate mediation. Okay, you find that our case management, if you include Hong Kong, Greater China is the biggest user, and then India is the next highest user. Okay, we have mediated disputes up to 1 billion. By the end of this year, it will go up to about more than 3 billion because we have some large cases that came in this year. This is data as of last year. Okay, settlement rate, as I said, is about 78%. Okay, so geographically, parties, they're all from all over the place. You'll see that on the left side, there are quite a lot of European and US clients as well. Dispute sectors, it runs the whole gamut. I mean, everything, including crypto assets. We had 2 recent cases on crypto asset disputes, and we expect to see more. We also conduct mediator training, and SIMC has been certified by CME to train mediators to set competencies who can then apply for accreditation by CME, because CME is a Singapore accreditation body for mediators. Now, we are going to roll out a new course next year for mediation advocacy. So we are training lawyers on how to be lawyers in the context of mediation so that they can facilitate rather than be an obstacle to the settlement process. And this course has been accredited by International Mediation Institute. Okay, let me end with 3 case studies. I will be quick. The first is a joint venture dispute. The second is a technology transfer dispute, and the third is a trademark dispute. Now, the first is under the GIMC, SIMC COVID protocol. This protocol was set up with the Japan International Mediation Center. And under this protocol, they appoint a mediator and SIMC appoints a mediator. In this case, it was a joint venture dispute of a joint venture in India between an Indian party and a Japanese party. And there was a lot of, they commenced court proceedings in India and arbitration at SIC, but then the parties decided to move to mediation. And so SIMC appointed a mediator, GIMC appointed one. The GIMC appointed a Japanese mediator who could speak to the Japanese party in Japanese, whereas in SIMC, we appointed a Singapore mediator, an Indian, ethnically Indian mediator who could speak the language of the Indian party. And the mediation was conducted fully online. And by the second day of mediation, the parties had in principle agreed to settle the dispute. Okay. Now, this is a case which we can be more open about because the settlement agreement was lodged with the Singapore, the Securities Exchange, and so it's public knowledge. This involved a US company transferring technology to a Korean company, and the claim itself was $1 billion US dollar, and there were 5 ICC arbitrations set up in 3 different jurisdictions, and there was also 1 court action or 2 court actions, I cannot recall, in the US. But after 4 days of mediation, 90% of the issues were settled, and the rest was settled within the next 3 months. Okay, this is interesting. If you go to our website, there is a video of the 2 counsels who handled this, and they gave a backroom explanation as to how they got the parties to settle and the things that they had to do to get the parties to even come to the table. Okay, so it's interesting to watch. And the beauty of this is that the mode of arbitration was in person. SIMC sent a mediator up to Korea to mediate, and the outcome was settled. Settlement reached in 4 days, with the remaining issues settled within 2 months that followed. But more importantly, like I say, expanding the pie, right? The settlement agreement had provision for the subsidiary of the Korean party to place another order of from the US party worth 66 million. Okay, so both parties benefited from the settlement agreement and they continued their relationship. Both parties needed each other actually, but they just couldn't see eye to eye as to how to resolve the relationship. The Korean party, the US party needed the Korean party to break into the Korean market. The Korean party needed the US technology to fulfill its obligations to its other subcontractors and other parties that they have contracted with. But neither party was prepared to give way, and they went to litigation and arbitration until it was resolved at mediation. Finally, the third case study, which you might be more interested in, this related to products stolen from overseas factory. And the thieves then got the stolen stuff distributed to different people, and then they appeared on sale on e-commerce platforms. So the loss to the owner of the trademark was millions of dollars in US. So the owner then sued the reseller on the online reseller for breach of trademark. Now the parties attempted to settle on their own through negotiations without success. Then they decided to refer their dispute for mediation at SIMC. Okay. Now they started exploring creative solutions because and a satisfactory settlement was reached. The settlement sum was to be paid in installments, and the lawsuit was discontinued. One of the concerns of the party being sued was that they could not afford to pay the damages, and they agreed on a sum, and to allow them to be able to pay without disrupting and destroying the business, installments were allowed. But the most important thing was that the parties then agreed to collaborate to investigate alleged wrong action of the other perpetrators. So this kind of collaboration is not going to happen in arbitration or litigation, but because mediation allows you to explore the interest and to come out with creative solutions, this was how the mediation reached a settlement. Okay, so we see that the mediation is going to play an even bigger part in the days to come as a link between arbitration and litigation. I think it's complementary. I mean, there are certain cases that just have to go to litigation. Some may be better settled by arbitration, but mediation will have a part to play in both of them. Okay, so I'll stop here. If you have any questions, just let me know.
Okay, well, thank you so much. Does anyone have any questions? Amanda, did anyone message you separately with questions?
No, not at this point.
Well, if that's the case, we'll end here. Thank you so much, Bennett, again, for taking the time to speak to us. Very grateful for that. And to the attendees, thank you for taking time out to listen to us today. Have a good day.
Thank you.
Thank you. Bye-bye.
Bye.